BingX, a trusted global crypto exchange. Trade spot, futures, or copy top traders easily. Sign up via the link or referral code to get 30 USDT instantly, plus up to 1,500 USDT in bonuses for verification, deposit, and trading.
Title: Citizenship Bill Sparks Outcry, Adopted Children's Rights Under Fire. A proposed Canadian citizenship bill has ignited fierce debate, with parents of internationally adopted children voicing alarm over what they describe as a shocking and unconscionable erosion of their children's rights. The federal government's overhaul of the Citizenship Act, intended to facilitate citizenship transmission for Canadians born abroad and to rectify past exclusions, has inadvertently created a new hurdle for families with adopted children. At the heart of the controversy is a new requirement for Canadian children born outside the country to demonstrate a substantial connection to Canada. This stipulation, critics argue, unjustly categorizes adopted children as immigrants, failing to recognize them as the full Canadian citizens they are. The current legislative push aims to amend citizenship laws that, since 2009, have restricted the automatic transmission of citizenship by descent to foreign-born children if both their Canadian parents were also born abroad. A 2023 Ontario court ruling struck down aspects of this rule, prompting the Liberal government's proposed legislation to address these constitutional concerns. However, Kat Lantine, whose son was adopted from Zambia, contends that the proposed connection test unfairly conflates children born abroad with those adopted by Canadians within Canada. She emphasizes that her son, adopted within Ontario and Canada, knows no other home than Canada, making the demand to prove his Canadian identity deeply hurtful and unnecessary. Government officials estimate that approximately 2,000 children could be impacted by the bill's wording. Lantine fears that if her son, now a Canadian citizen, were to live abroad and have children, he would theoretically face the burden of proving his substantial connection to Canada to pass on citizenship, a test not imposed on individuals born in Canada. She passionately argues that this requirement is not only damaging to internationally adopted children but also violates international law, specifically the 1993 Hague Convention on Inter-Country Adoption, which mandates that adopted children enjoy equivalent rights in the receiving state. While Canadian provinces and territories adhere to this convention, Lantine asserts that Bill C-3 places the federal government in breach of its international obligations. The controversy intensified in early October when Parliament's Standing Committee on Citizenship and Immigration voted down an amendment proposed by Liberal member Nathaniel Erskine-Smith, which aimed to resolve this issue. Erskine-Smith himself declared any disparity between children born in Canada and those born abroad to be unconscionable. Tensions ran high during committee discussions, with Erskine-Smith expressing feelings of being absolutely misled by expert assessments of his amendments. While the Liberals, holding a minority on the committee, supported his amendment, it was ultimately defeated. Adding another layer of concern, two Conservative committee members raised apprehensions about potential child trafficking linked to adoptions from abroad. Lantine, however, strongly refuted this, calling it dog whistle politics that conflates child trafficking with the fundamental citizenship rights of her son. She stressed that her son's Canadian identity, forged through a lengthy and rigorous adoption process, is not a subject for partisanship or xenophobic rhetoric. The comparison to international practices further highlights the perceived inequity. Lantine and Erskine-Smith point to the United Kingdom's laws, which treat internationally adopted children as if they were born in the UK to a British citizen parent, allowing them to pass on citizenship seamlessly. Lantine's poignant plea underscores the deep emotional and national identity at stake, stating her son's lineage, with ancestors contributing significantly to Canadian history, should not be diminished by his birthplace. The core of the argument remains clear: